Good afternoon, everybody. It's nice to see everybody here today with our fifth webinar of the HR series. Can't quite believe that we're halfway through already. And today's webinar is going to be about contracts and changes, those variations. And hopefully, I know we've only got the lunch hour to get through this, but there'll be time for questions and answers at the end as well. Okay, so those of you who know me have probably spoken to me on the helpline at certain times or met me at the recent HR update day, which went really well last Friday. So my name's Karen Penfold and I'm the head of HR here for Code. So, and we're just going to touch now on the aims and objectives of today's webinar as well. So the aim really is to increase understanding of the correct process for varying contracts of employment, to help managers comply with employment legislation, and to discuss an overview of employee rights relating to varying contracts of employment, and to highlight the risks of not having a robust contract agreement in place. We're also going to explore how Code Total HR provides some useful policies and template letters to help practices comply with their legal obligations. Okay. So the learning outcomes will be to avoid potentially costly mistakes when varying contracts of employment and to improve understanding of the benefits of having a robust contract in place. We're also going to touch on the understanding some statutory employment rights relating to contracts and a little bit around employee status there. So look to get through. So session content, we're going to start with some legal obligations. This is really relating to what an employer's obligations are around employee contracts. We're going to look at types of different contracts that we have as well to consider those, and making contract variations. So rather than changes, which is a bit of a scary word, we're talking about contract variations, making and agreeing these changes. So the correct process so that you're not at risk of any tribunal claim there. We're also going to look at some summary of risk at the end as well, some actions for next week, and also some useful policies and templates that we have on iComply that I'm going to refer you to help with making contract changes, and how important it is, particularly when you're making changes to employees' contracts, to get the right advice at the right time. So if we just look at the legal considerations first, so essentially when we're talking about contracts, and this is what is a contract? So the definition is essentially it could be a promise or set of promises between one or more parties, which is enforceable, legally enforceable. So obviously that's a bit of a mouthful there when we're talking about the legal terms. So essentially a contract is about there has to be an offer of a service or work in place. So you make that offer is accepted. And then there has to be some kind of consideration involved, which tends to be relating to pay. And that is both parties are agreeing to that they are setting up a legal relationship. So when we're thinking about that in an employee's sort of context, so when you're making an offer of employment to a new employee, which quite often is verbal first over the phone, then that verbal offer, you're offering them the work and they're accepting it, you're paying them for that work, so you're already creating a contractual relationship between you both, which is why we always specify to make sure that those offers are conditional. So if you need a bit more around that, have a look at our previous webinar on recruitment as well, which Sophie did a few weeks ago, that to give you some ideas around making those conditional offers. So normally they should be a written contract when we're talking about from an employer's perspective. So it's a written statement of particulars, or it could be a written, actually formal contract in place. And for an employer, now legally you need to provide a contract of employment or written statement of particulars to your employee within 8 weeks of them starting working for you. So when we're talking about written statement of particulars, this is essentially in a contract. It outlines all of their employee rights relating to all their entitlements and on both parties and what you're signing and agreeing to. Now, failure to provide such a contract, and quite often we speak to members who aren't providing these until after, say, a probationary period, not realising the repercussions. Failure to provide would essentially be another sort of 4 weeks pay on top of any claim that they might take you to a tribunal over. It seems to always be in addition to another claim, but it is also a factor there. It's not just about the cost though. I'm going to talk about the importance of why having a contract in place is so important, not just about the penalty, the legal consideration. So we talk about different types of contracts. Now, on iComply and Code, we're well known for our contracts. And say we've got some very robust contracts in place, and we have a range of contracts on here. So normally our staff terms and conditions contract is our most popular. And this is for your full and part-time staff, your permanent team members. It's also there for fixed term contracts as well. So it tends to be used for maternity when you're offering a maternity contract in place when a team member is going on leave. Now, when we talk about fixed contracts, it has to be for a fixed period. So it can't be that you're giving them a rolling contract year on year. And unfortunately, we have spoken and worked with employers and members who have made that mistake of thinking a fixed contract can be issued year on year when actually it has to be when the work is only required for a fixed period. Now, if you are coming to an end in a fixed term contract, please seek advice when you're doing that, because essentially you still need to give notice that that contract is ending. And that's because essentially it is a termination, it is a dismissal when a fixed term contract ends. And there could be a risk there of some wrongful dismissal claims around that. So temporary contracts, we have lots of these in place as well. And this tends to be really for 3 months plus, but shouldn't really be any longer. And even this is pushing it a 2-year sort of basis, because then you are moving into full employment rights as well. So temporary should be exactly that, where you only require them for a temporary period to carry out a short-term work assignment, for example. Now, 0 hours contracts, we do have a separate template, contract template in place on iComply for managing your 0 hours workers. And it does get a lot of bad press, 0 hours contracts, but essentially people don't always hear the good things about them. We do speak to a lot of employees that actually like these because of the flexibility they provide, and they work very well for members as well. So if you are looking to issue a 0 hours contract, then again, get advice first to make sure it is the right contract to be in use. And they can also be known as casual or irregular hours contracts. You might hear that terminology as well. So now we're moving down to another type of contract, which is agency contracts. Not my favourite, to be honest. And those of you who probably work with agencies or use agencies, I'd always advise to read the small print in these to make sure what you're signing up to. And they can be negotiable as well. And recently, we have seen an increase in our dental nurse apprenticeship agreements being used. Now, these are a completely separate agreement in place than our employment contract. Now, apprenticeships, apprentices have a different level of protection under legislation, and that agreement and framework. The contract is very important that it meets that requirement. So making sure that you're using the right contract in place. And it can either be, we do see some confusion sometimes over whether they're a trainee dental nurse or whether they're actually a dental nurse apprentice. Now, you'll know if they're an apprentice because they'll be working to a framework. But again, please get advice to make sure that it's very important they're on the right agreement. Now we're moving down to self-employed agreements. We're very, again, well known for these on iComply, and we have about 15 different templates of contracts in place, with our most popular being the provider performer contract. This contract is incredibly robust and strong, and it's based on a lot of work we've done with members over the years of what works for them, and also with our dental solicitors to create this robust contract to protect our members and to work well for you. This particular contract is there in place for those who have mixed practices. So NHS and private practices would use this for their self-employed associates. So the different terminology for self-employed agreements, these are known as contract for services or consultancy agreements, contractors, but the terminology is really important here when we look at employment status in a moment. So it's contract for services. Now, we still see an awful lot of arrangements in place that are verbal contract agreements only. And we speak to members, and I understand the reasoning for this. A lot of it is around, it could be a family member that they say, we don't need a contract, we trust them, their family, or their work colleague, someone they've worked with a long time or went to university with, and actually say, we don't need to have this type of contract in place. Now, as I mentioned before, verbal contracts, verbal agreements are contractual. However, when we look at disputes in a moment, that's where having it black and white in writing will help resolve those issues. But not only that, it's also around employment status. Now, to be honest with you, this particular slide, we could probably spend a whole webinar talking about employment status. Not sure how interesting it would be for you, but it's a very complex area. It's very prevalent in the news. You may be familiar with the government when we're talking about the gig economy, the government's Taylor report, and IR35 is another one, but also recent case law, which is impacting on employment status in terms of Uber and Pimlico. And this is not just around, obviously, HMRC and the government wanting to make sure that they've got enough tax and that everyone's paying the correct amount of tax. It's also heavily linked to making sure they have the correct employment rights involved as well, that they are fully protective. And that's why that is in place. So it's just an awareness to be aware of that. So when we're talking about defining an employee, what's the difference to an employee, a worker, and a self-employed / contractor type of person? Now, I think the way to sort of look at this is the higher degree of control that you have, the more likely there is to be an employer and employee relationship. It is all about the control, but also having a robust contract in place, which states they are an employee or self-employed, is one key thing, but it's also how they are treated in that relationship as well. So, for example, an employee would have a contract of employment. They would have set hours. They would be paid regularly for those hours, the same amount each month. They'd have a line manager, someone to report to, pay slips. They'd also have to sign up to your grievance and disciplinary procedures as well. Whereas a self-employed person is very different. Their pay should fluctuate. They should be a degree of financial risk. Also, they should be able to, this is the key thing that makes somebody different to an employee. They should be able to substitute themselves and not have to personally do the work themselves, which is where we know with our associates and self-employed hygienists, that factor, that they're able to send in a locum and they don't personally have to carry out the work, whereas an employee does. Now, a worker is slightly different. They have to carry out the work, but they are able to turn down work. And the employer is not obligated to always supply them work as well. So that's one of the differences. However, with the recent reports happening, there's so many, we're looking at about 10 different categories of employment status. And we know in the dental profession, it is very unusual how our self-employed associates and hygienists are able to be seen as self-employed workers, self-employed contractors, I should say. However, on paper, it sometimes can look as if they are actually have worker or employee status. So this is an awareness around this. So if you have one of your associates who only works at your practice, doesn't work anywhere else, has worked for you for a long time, is effectively treated like an employee, they're paid hourly or they're expected to apply for annual leave in the same way as an employee, you're starting to create that level of control, and it's starting to look more as if they could be a worker or an employee. And there has been recent case law where this has come into and happened, and actually they've been successful in winning that case as well. And unfortunately, the onus at a tribunal isn't for the self-employed associate to prove that they were an employee or worker. The onus would be on the employer to prove that they weren't. And the same test of this is used as the same as IR35 test to see if they are truly self-employed or actually have worker status. So this is really an awareness to think about your relationships. And if you have any confusion around that, to have a strong contract in place, which will protect you, but also how you treat them day to day as well is another factor. Okay. So when we're going back to employment contracts now, and really focusing on the different types of terminology that you hear. So there are express terms. Now, this is really what is written down in the contract, and certainly covering all of their employment rights. And it should highlight, going back to that statement of particulars, everything that they're entitled to under Human Rights Act and their employment protection. So that's what's written down in the contract. Now, if you had to write everything down that you were promising your employee in that relationship and vice versa, you'd have a huge contract in place that would be incredibly difficult to manage and refer back to. So this is where we talk about implied terms. Now, implied terms are those that are so obvious that you shouldn't have to state. So, for example, you shouldn't have to state in the contract that the employee will not steal from you. It's implied that both parties have agreed to that level. What I haven't put on here, and is something I don't know if you probably may have heard of or come across, is the psychological contract as well. So it's a mixture of implied and custom and practice. But when we're talking about psychological contract, that's essentially the relationship between the employer and the employee. That mutual trust, that respect relationship that is actually, you shouldn't have to write down, but it is also contractually binding. And that one is more important sometimes than when you lose an employee's engagement. And we're going to talk about that whilst we look at making those contract variations and changes. So going back to why do we actually need a contract? Is it just a tick the box exercise that we have one in place? It is all about prevention, to be honest. It is also making sure you comply legally, that you have a contract in place in terms of employment law. But having a contract that sets out your standards and your framework for your employees is one thing, that everybody knows what they're expected, where they stand. It makes life a lot easier to manage as well in terms of your employees. But it also, you know that everyone is on the same page and there's no grey areas. Now, for a self-employed consultant, not having a contract in place where it's only verbal, and we have seen a huge increase in, unfortunately, disputes between associates and practice owners where there haven't been a contract in place, and it tends to be around whether there's a retention figure or where the restrictions are, or also how much notice they have to give. And obviously those sort of factors, if they're not written down, it can end up being one word against the other. So what you do with a contract, it makes sure that there's no grey areas. So I'd really focus on making sure all your self-employed associates have a contract in place, as well as your employed team members. Okay. So when we're varying an employee's contract, so I've put varying an employee's contract rather than changing a contract. So I think quite often the word change is already puts that sort of fear into your employees that you're going to do something they're not going to like and you may not get them on board. So it's a variation to their employment terms and conditions. I think types of variations, we have again seen a big increase on this on the Total HR helpline. And this is around changing their hours and work patterns, particularly where dental practices now have to open longer. So it might be increasing your hours in the evenings and also at weekends working as well. So you're having to talk to your employees to get them on board with that, to make that contractual change. And also a common one is removing enhanced benefits. Now, this could be particular where you've been paying sick pay, for example, and it's been enhanced sick pay. And we've spoken to members who now want to remove that because it's not sustainable for the practice, and they want to replace it with SSP only. Other types of variations can be a relocation, a restructuring to their job role. And we've seen a lot of practices that want their team members to be more multi-skilled and take on additional work and responsibilities. And that would be a change to their contract as well. And also notice periods. And we know from talking to members at the moment, there is a real struggle around recruitment in particular. So we've seen an increase in them wanting to speak to their team members to increase their notice periods to protect yourselves in that sense as well. So it's not all doom and gloom. It's not all negative variations that happen. There are obviously nicer changes in terms of pay rises. It can be a variation, or promotions and changes to job roles in that sense. But also on the other side, you could have an employee coming to you asking to vary their contract in terms of the flexible working request as well. So the reason I have TUPE on here is I don't know if any of you have come across this or have heard of it or aware of it. We do get a number of, on the helpline calls, it can be called something different every time. I had a call put through to me just the other day from a team member who was advised that a member wanted to talk to me about TUPE, a team member's TUPE. It was actually, so we've had TUP, we've had all sorts of this being called all sorts of things. It's quite a complicated area of case law. And the reason I wanted to include it on here is that if you are buying a practice or you're about to take over a practice, then the team members that are there currently will be protected under TUPE, which means it's a transfer of undertaking for protection of employees. And it does mean that they have an extra level of protection on their terms and conditions or any changes that you make to them. So that, again, we are going to cover this in a later webinar in more detail, and we'll be talking about TUPE. But if you are in that situation, then please seek advice, because it is a quite high risk area if it goes wrong. Okay. So change, again, that horrible word. Some people love it and some people, it makes them incredibly nervous. And I think the key word here is that when you are looking to change or vary your team members' contracts, it should be put forward first as a proposed change. So it's not a given change, it's a proposed change that you're looking to implement. So if we take the scenario where you are looking to talk to your team members about changing their hours and work pattern in terms to meet the business needs, that you need them to work later and work on a Saturday, for example. So the first step you would put down those changes, what those proposed changes are going to be. They need to be put in writing, and you need to give your team members, your staff, at least a month's notice of when that proposed change you're looking to implement it. So I would advise, if it's a change that's going to affect your whole team, that you call them together and you advise them of the change collectively. So this is a much better way than if you tell them individually. Quite often it can be a sort of a succession of Chinese whispers and everyone's heard something different. So it's better to tell them all together what you're looking to do, that proposed word going in there, and that you'll be putting it in writing to them, and you're hoping to put this change in place within a month's time. However, there needs to be consultations before that proposed change is going to happen. So the first step is making them aware of it, making them aware of the business reasons for it, and then you'll be meeting with them individually to talk to them about the change and the reason that you need the change to happen. So in terms of meeting your patient needs, it's better for the business, it will strengthen their roles. But in those consultations, what quite often happens is that the employees have ideas themselves, something you may not have thought about, and it's an opportunity for them to put their side across and express any concerns they may have, or they just need clarification on why it's going to happen and what it means to them as well. So that's a very important stage, and I know it can seem quite time consuming to have to put all this effort in talking in consultations, but it will pay off long term, because the idea is that you're trying to seek their agreement. Now, this is the most key thing about when you're varying your team, any employee's contract. It has to be mutually agreed by both parties. Any change has to be mutually agreed to be able to be to go forward and to be legal as well, and to protect you from those constructive dismissal claims going forward. So the idea of the consultation stage is to seek their consent and their agreement to the change. So if you're in a really fortunate situation, and like you see in this picture here, that everyone's happy and they're happy to sign up to the changes, you've gone through the consultations, then it's important that you've got an audit trail that they've signed to agree to that contractual change as well. Now, we have on iComply a template document called Subsequent Changes to Terms and Conditions. So this is the one that we'd recommend you use when you're making a change like this, and that is issued to all of your team members that have agreed to the change and when the change is going to happen. And that would be kept in their employee files as an amendment to their contract. So it's important that you keep that in place. Now, on top of that, if you're in a situation, unfortunately, where they are refusing to accept the change, now, I know nothing is straightforward. And again, the more communication you have, the more engagement with your team members prior to this, there is the higher likelihood that you will get them on board to agree this change happening. So if you are in a situation, your team members are turning around and saying, no, they're not happy, despite the consultations, consider incentives. Now, I'm conscious that a lot of the changes you're looking to make are to try and make costs, to increase efficiency and to reduce costs. So I can understand not wanting to throw more money at employees to get them on board. What we find works quite well seems to be flexibility in terms of working. If they are doing more hours, is there an opportunity to do some toil, create some toil from there? Could that be an incentive that they get a day back in that way? Also, bonus schemes as an incentive can work well. Or as a compromise, you may have to consider gradually phasing out, for example, phasing out the sick pay, so they're not removing a benefit all at once. So really consider this and get them on board. But listen to your team members. The staff may have an idea, an incentive that will engage them as well. And it might be that you've got 10 that are happy to sign up and have no issues. And there's that one team member who has a strong objection to this. So what we find the next step then is, if you have someone who is refusing to sign and agree to this and is really unhappy about this change, is you ask them to put their reason for the refusal in writing. Now, being honest with you, from HR experience, and I think my team members will probably agree with this, what tends to happen as soon as you ask someone to put in writing what their reasons, their grievance, what their reasons are, they tend to withdraw that, not want to do that, and then you will find you'll get them on board and they will sign up. However, if they do state in writing that they're really unhappy and they're not going to sign to this change, you need to treat that as a grievance. So essentially, you would work through your grievance procedure with this employee to if they put forward saying, for example, that they feel this is a strong breach of their terms and conditions if you were to make this change, then you would treat that through the grievance process and deal with it in that way. It's very important that you do that. And I'll talk about the risks of not doing that in a moment. For those of you who are not familiar with the grievance process, we do have a webinar online that I think Hannah did recently, all about grievances. So have a look at that if you need some help there, but also come to us and get some advice if you're unsure as well. Now, if they don't put anything in writing and they're not raising a grievance, but they haven't signed to say, yes, okay, we agree, we are going to go with this change, then that could be treated as essentially working under protest. So if they haven't signed the amendment to their contract, but they haven't put anything in writing, but they are saying to you, I'm not happy, but I'm still going to turn up to work, accept payment, but I'm working under protest. I've made that clear. The risk is with that, that it could eventually, if they were then to leave, they could try and claim that it was a constructive dismissal process, that they didn't sign and agree to any terms and conditions, and they might try that route. However, the longer it goes on, and when they're not actually putting in writing what their actual grievance is, the more likely it can be deemed it's implied that they have accepted and with those terms. But again, I would always try to seek that agreement in writing as well. So a very last resort, and we do get calls, and when this is so frustrating, if it has got to the stage where nobody is agreeing and they're not happy to accept they've gone through the grievance with you, which you've upheld and said, no, I still need to make these changes for the business needs, then the last resort that employers can take in this situation is effectively would be terminating their current terms and conditions, and they would re-engage them on new terms and conditions. So effectively, you would notify them, you would give them notice that their terms and conditions are ending. So whatever notice period it states in their current terms, so for example, if it's a month, you would give them a month's notice, which is effectively a dismissal. And then you would offer them the re-engagement on the new terms, a new contract of employment to take up. Very, very high risk area in terms of effectively you are dismissing someone, and if they've got 2 years of service, they would be able to go for a constructive dismissal claim or an unfair dismissal claim, depending on the process that you followed. So it is risky. Some employers are quite successful in taking this action if they can show and demonstrate that they have tried to engage the team member all the way through, they've been acting reasonable, they've consulted with them, they've treated their grievance fairly. And it can look at, with the tribunal, they will look to the fact that you have offered them, they haven't lost their job or been made redundant, you've been reasonable as an employer, and they will actually look at how the employee has acted as well. So even though it is high risk, and I'd get advice at first, and it should be a last resort, it can be deemed by a tribunal to be a fair route that you've had to take there. Okay. So I just want to talk about when I haven't put a slide in about this before I talk about the summary of risk, but when we speak to a lot of members who are interested on trying to change a associate's contract agreement, so a contract for services, a self-employed contract. Now, if you're on a code contract, there are clauses within that contract that talk about variation clauses. So there are several clauses in there where you're making a minor variation or a bigger variation to the contract, which you then need to give them 4 weeks notice of. So in terms of a self-employed contractor, that you would meet with them, you would advise again in writing that you're planning to make this change to their contract, and it could be you want to change the minimum hours they're working or the number of UDAs. You would still consult with them, but not using the same terminology you would with an employee. However, it's a lot more straightforward in a lot of senses because you don't have to necessarily seek their agreement. If they're not happy with the change, then you are able to give them notice to terminate that contract. However, if they are happy, then you still need them to sign and say that they've agreed to that variation to their contract clause as well. And again, obviously you want to keep that associate and keep them happy, but if they're refusing to sign up to your new terms, then you don't have to go through the whole grievance process and everything else because they're self-employed, and last resort would be having to give them notice and just to terminate their contract for services. However, going back to the employment status side of things, if it transpires that you have an associate who has worked for you for a long time and they may actually have worker status or employee status, and you're looking to make changes to their contract, then they could effectively, if they're really unhappy with this, they could make a play to say that they were an employee, and there is that risk of a tribunal. So please get some advice if you are in that stage and you have an associate who's worked for you in a long time. So just touching on risk around not issuing a contract. Now, I mentioned earlier the financial penalty from an employer's point of view is that 4 weeks notice. So if you are not issuing them a contract of employment or a written statement of particulars in that first 8 weeks, and things go wrong, they might be able to claim wrongful dismissal. But then on top of that wrongful dismissal claim, they would also be able to allocate another 4 weeks on top in terms of financial penalty for not issuing a contract. But not just that. I mentioned earlier, it's not just about the financial penalty involved. It's also the fact that you having that structure in place for both parties, knowing exactly what the standards are, will help you in managing that employee and team member as well. So I think that part is almost more important than the 4 weeks risk of that 4 weeks penalty. If you make changes, contract variations without any consultation or without seeking their agreement and having that mutual agreement in place, this would be considered a breach of their contractual terms. So in that situation, you are at risk of them claiming constructive dismissal, wrongful dismissal if they have the length of service. But not just that. I've put in here about the employer and employee relationship. It's that breakdown, talking about the psychological contract earlier. If, as an employer, you bypass the consultation stages, and we have seen this, and it's done because they're looking at how much time and just the agenda that's in place of what they're trying to achieve. If you were just giving a letter out to your team members to say, from next week, you'll all be having to work a Saturday once a month, you're going to break that psychological contract between both parties, which can be more damaging in a lot of ways, because trying to get your employees back to respect and want to work for you, and that mutual trust when it's been broken, is quite hard to win over. And it may you may end up losing them, the retention side. They may decide to leave, and they may not even go through making a claim or anything like that. But it is about your retention and the morale and the practice as well. So try and, even though it looks like a lot of work to seek their agreement, it does pay off in the long term. I mentioned constructive dismissals. I don't want it to be all doom and gloom, but these are the risks if you're not following that fair process. So a constructive dismissal, an employee who has 2 years of service would qualify eligible to make a constructive dismissal claim or an unfair dismissal claim. And these arise from breaches of contract. Constructive dismissal is when there has been a fundamental breach of their contractual terms, and they have to prove that breach. So if you are in the unfortunate situation, which I hope doesn't happen because you'll get advice beforehand, is the claim process. So if you have an ex-employee who has decided to make a claim, and unfortunately we have seen since the tribunal fees were withdrawn last July, there has been a 90% increase in tribunal claims. So this means anyone that works for you, whether it's for a day or several years, is able to make a claim and throw that hat in to make a claim against you. So the first step, though, the government have introduced ACAS early conciliation. Now, an ex-employee has 3 months, less than 1 day, to make an employment claim against you for whatever reason they're going for. However, with ACAS early conciliation, this effectively stops the clock and gives you another month of negotiations between both parties to be able to reach an agreement or a settlement to ideally prevent it going to a tribunal. What ACAS do, they do not make any judgment on who is right, the employer or the employee or whoever has a case. They literally mediate essentially between both parties. There's also some reassurance there if you do make what we call a commercial offer. If you decide actually there are some risks there, I don't want this to go to tribunal, even though I think I have a strong case, I'd rather not spend more time on it, so I'm going to make a commercial offer, or whatever that figure is. If that person didn't accept it and it ended up in tribunal, it wouldn't be submitted. It doesn't mean it's a submission of guilt there. So, but I would say if you are in that situation of, hopefully that will never happen, but if you are, to please seek advice at every stage to try and help you support this to prevent that from happening. So key policies and templates. I mentioned that we're well known for having a lot of contracts and robust contracts on our iComply system. So those that have associates, particularly working in a mixed practice, I really strongly recommend the provider performer contract agreement, which is M237G. Have a look at that alongside the guidance notes for that. That will help you complete it as well, and give us a call if you have any confusion or areas of concern around that. Also, another one to really draw your attention to is the subsequent changes to terms and conditions. That is the amendments. When you are making and agreeing changes with your team members, it doesn't mean you have to issue them with a whole new contract. I would advise checking how up to date your contract staff terms and conditions is first, whether it's a lot of changes you're making. You might be better to issue a fresh one, or but make sure you have this amendments in place as well. So I think I've just, I think some of my slides have just jumped. Apologies. Okay, so I mentioned we've just jumped a couple of slides across, like technical hitch, but the actions for next week is to, I think, to make sure all of your team members have a contract in place and that's signed and agreed. Thank you for putting those back. And also, and that is signed and agreed and the contract is on their file. This is also something that CQC inspectors will come in and look at and see if they're in part of their checks as well. So make sure that's in place. And any changes that you have made to contracts of employment, that those amendments are also reflected in that employee file in case you need to check. And also, if it did come to TUPE and you were selling the practice, you have an up-to-date record of that employee's rights and what terms they're actually working under at the moment. And again, if you are seeking changes and proposing to make changes, please get some advice first before going straight into it, and just to avoid those longer term risks of constructive dismissal or losing the engagement of your employees. So those I can see actually online today, we've got some total HR members with us. So thank you. And we met, we saw quite a few at the HR day on Friday as well. So this is something we have put together from members' demand really, and seeing what their needs are. We offer total HR and employment law service. This will provide you with all of your HR documentation. We also make sure that you have your contracts, really important that you have your contracts set up and that every one of your team members has a strong contract in place. So not just your employed team members, but your self-employed as well. And we do an audit to make sure that you are up to date. And that's where we look at whether any amendments have been affected as well, and that you have that record on file. I think one of the things that we really found from the service that we're offering is that there's that need for wanting us to write and create template letters. So for example, if you are going through making changes to your employees' contracts, in the total HR side, we will create those templates and those consultation letters for you as well and support you through that process. It's very hands-on, and you'll get your own dedicated HR advisor to look after you as well, to get to know you on that. So if there is anything you want to know about that service, then please speak to, it's a contact number there. You can speak to our professional services team. Upcoming events. So we have the next webinar, webinar 6 with Hannah on the 29th of November. So that's managing staff performance, and we will be covering in that webinar, looking at how to conduct an appraisal, also staff competence records, performance improvement plans. And again, this is from something that we find a lot of members are asking us about, so that's why we created this one. That is our last webinar of this year, and then we'll be starting again in February next year of some, and we'll be sending out the schedule, more information on those. We do have our compliance update day next Friday, the 23rd, which is quite exciting. Lots of different topics that are going to be happening there. So if you're interested in joining that on that day, then we've got the link there below. Just click on that and you'll be able to register. So we're just coming to the end of the webinar this afternoon. Thank you again very much for attending, and I hope you really found it useful and given you some information there that you can go away with as well. So we're just going to move now into our Q&A session. So thank you again, and hope to see you soon.